SJC-12472, Amanda S. Oberlies and others, v. Attorney General and another.
I'm sorry. Mr. Nathanson, good morning.
Good.
Still good morning.
Still good morning. I have to confess, this is a unique experience. I've never gotten up to argue an appeal that was pre-argued while I was sitting in the audience. And it
Like
in a
Groundhog,
way makes sense.
It's like Groundhog Day.
So, yes, this is another ballot petition appeal, and yes, these two ballot petitions, for want of a better word, are related. There is one other distinction between 1708 and 1707 that I noticed when I scoured them to look for distinctions, and it's just that the title of the proposed statute in 1708 is the Patient Safety and Hospital Transparency Act, and in 1707 it's simply the Patient Safety Act. Since 231K isn't part of 1707, the relatedness issue doesn't turn on the relationship between 231K and the patient assignment limits. Instead, it turns on the relationship or lack of relationship between the patient assignment limits expressed in 231C and 231D, the no layoffs provision that Justice Kafker just mentioned, which provides that implementation of the patient assignment limits required by 231C shall not result in a reduction in the staffing levels of the healthcare workforce. Now, there's a definitional issue buried in this, and it's been discussed in the briefs that I'd like to discuss first, if it's okay, because I think while it's not necessarily dispositive, it does provide possibly the clearest path to a disposition here. Section 231D prohibits reductions in the staffing levels, layoffs, in the healthcare workforce. Healthcare workforce is a defined term in 231A.
Yeah, but it has to be in order to implement the patient-nurse ratio. It's just not a workforce restriction, and the definition of it, I'm sure you'll have issue with, but the workforce restriction, when you analyze it, the language I thought is being tied to the patient-nurse ratio.
It is tied in that sense that it's implementation of the patient assignment limits that shall not result in a reduction of something.
Right.
Okay. What that means, if you want to put it in terms of something that you also discussed earlier, is that there's a unilateral dependence between 231D and 231C. 231D would have no place in the world, it would have no home to go to, but for 231C, but for those patient assignment limits. But that doesn't satisfy the mutual dependence requirement in Article 48 because the provisions are not mutually dependent. 231C could exist very happily without this no layoffs provision. And in fact, there is already on the books the analog to this, which is restricted to Section 231, Chapter 111, Section 231, which is restricted to ICUs, sets patient-nurse ratios for ICUs, which exists without any kind of a no layoff provision. So while there is this unilateral dependence, the question of relatedness, I think, goes deeper. It depends on the purpose of the two provisions, the purposes of the two provisions, which in turn depends on the effects of the two provisions, which in turn depends, in some part, on this definitional issue. Mm-hmm. Okay?
Well, let me ask you this.
Sure.
I mean, I think you can agree that the overall purpose of this statute is with regard to patient safety, with the view that the ratio of patients to registered nurse is an important element of the quality of care to those patients, correct?
It's an element of the quality of care, yes.
So is the purpose of that statute satisfied if a hospital says, well, we need to maintain a 2-to-1 ratio, the way for us to do it is to lay off LPNs, lay off maintenance people, lay off secretaries and impose upon those same nurses burdens that they didn't otherwise have to perform. So that, yes, we have a 2-to-1 ratio, but now we're asking nurses to clean bedpans that they didn't have to otherwise clean, and we're asking them to do clerical work that was previously done by others, and we're asking them to perform functions that a licensed practical nurse had performed, so that in effect, the ratio is being undercut because now these nurses have to do tasks that they were not previously doing, and therefore can't pay the same attention to the patient as they did before.
Sure, and that's the rationale that's articulated by a couple of the amici, the Massachusetts Nurses Association and the California Nurses Association. The MNA puts it that the petition ensures that hospitals cannot perform an end run around the statute by depleting the other important staff members who assist nurses. And the CNA likewise talks in terms of ancillary staff, support staff, people who do the kinds of things that you were just discussing. If the healthcare workforce were defined in a way that restricted it to those people such that you could articulate that kind of connection or that kind of risk of circumvention or an end run, then you could make the argument that both provisions are related to the common purpose of patient safety. I mean, the AG has defined the common purpose differently. She's defined it in terms of just establishing the patient assignment limits. And I don't think that you could, even in that narrow articulation, that you could say that that purpose would be served. But since we're talking about patient safety, let's stick to patient safety. But the problem is that the statute doesn't say that, okay? The statute doesn't restrict hospitals from laying off the kinds of people who, if they were eliminated, the new nurses, the extra nurses, would have to take on their jobs, and therefore there wouldn't be any value in adding nurses or mandating those ratios. And it casts a net so broadly that it is not serving that purpose of patient safety and presumably is serving some other purpose.
Now, what do we do? I mean, 231D speaks about a result in a reduction in the staffing levels of the health care workforce. I understand your position that that goes beyond it, but then 231E, as Justice Lowy referenced, speaks about shall not result in a reduction in the staffing level of the healthcare workforce assigned to such patients, and is therefore more precise than 231D in that regard. So what do we do with that?
Well, in terms of determining what the statute means in its operational sense, 231D is the operational term. Certainly, in drafting this statute, the proponents could have written 231D to say that it shall not result in a reduction of the staffing levels of the healthcare workforce assigned to patients, or alternatively, when it defined the healthcare workforce, it could have defined the protected workforce in terms of who's assigned to patients. So in that sense, 231E has no relevance. On the other hand, I think it does have some relevance because when different words are used in a statute, they tend to mean, they're taken to mean different things. This is a provision that talks about, 231E is a provision that talks about regulations governing the certification plans that each facility has to prepare for implementing the patient assignment limits. Now, whether 231E entitles the HPC to narrow the scope of the certification plans is one thing, but nothing in 231D suggests that that hospitals can narrow the scope of the healthcare workforce whose jobs they have to protect. And in fact, if you read a little further down into 231E, it says that notwithstanding the terms of this or any other section of this act, the HPC can't promulgate any regulation that would modify the requirements of 231D.
So let me ask you this. If 231D had said, implementation of these limits shall not result in a reduction in the staffing levels of the healthcare workforce assigned to such patients, would you be here?
I'm not sure that that would be grammatical because there's no antecedent for the patients.
Let's assume they fix,
there might
let's
be
assume
some
they fix
way,
the grammar, but
there
maintain
might
that.
be some way in which that would be sufficiently tied to the purpose of the statute and the risk that has been identified of end runs or circumvention of the statute so that we would not be here. But that's not what the statute says. It casts a much broader net.
But do we do that? I mean, that's why I asked in the last case about overbreadth or narrowly tailored. Do we do that in initiative petitions? Do we say it's related but too broad?
You do, and I think you have to. Let's look at the opinion of the justices case, the 1996 case. I think you need to do that because when you look at the case law, one of the primary concerns that motivates the relatedness provision is this concern about log rolling, which at least in one of its manifestations is defined as the practice of hitching one provision to another one or burying one provision in another one. And so the risk you have is that you may have a statute that while if you look at the first paragraph, it looks like it's doing something that's related to the overall purpose of the statute. There's something further down in the statute that is not. And so that's why I say I think you have to. You have done it, as I read it, in the opinion of the justices to the House Representatives case. That's from 1996.
What's the cite on that?
It is 422 Mass 1212. And that was a statute that, in large part, the primary purpose was to put restrictions on legislative compensation. But one of the things that it also did was that it tried to accomplish permitting the state auditor and the inspector general to oversee legislative, financial accounts, and purchasing activities. And to do that, it repealed an existing provision in the public records law which protected records held by the general court from inspection by the inspector general. But it so happened that that same provision also protected certain papers that were held by the Commissioner of Veteran Services. So that one provision did two things. It took away the protection that was given to legislative papers, but it also happened to take away the protection that was given to papers regarding to the veteran services. And this court looked at that one statute, didn't say that the provision relating to inspection of legislative papers was.
But all this has got some kind of relationship. It's just, clearly, as the chief redefined the statute, that would clearly be related. If you wiped out, licensed nurses to make room for registered nurses or got rid of physician assistants.
Yes.
And they're going to have to deal with the consequences of the cost somehow. They're going to have to, the hospitals don't have unlimited resources. They're going to have to make cuts somewhere.
Yes.
So, but does that suggest that, that the relationship could be narrower, but it's good enough for government work? I'm just trying to understand, because that provision you just cited is pretty afield. It's veterans. Here, all of this relates to hospital staffing levels.
It relates to, yes, but the reality of a modern hospital is that it has functions and functionaries who cover a much broader spectrum than what's done at bedside.
Right,
And so
that's clearly true, but.
And so sweeping up virtually everybody in that spectrum.
So because this no layoff is an enticement, it's saying all healthcare workers are going to get protected. By the way, how does it work? So you can't lay off anyone, what is your understanding of you can't lay off anyone as a result of this? Anybody? I'm just trying to figure out how this works, because over any period of time, I don't know how it works.
Well, it's a cause and effect relationship, but because it's not a one-time event. I mean, there's going to be a first-time event where by January 1st, hospitals have to come into compliance. But hospitals are always going to have to maintain these levels. And as patient populations change, the number of beds change, things like that, every year a hospital's going to have to make sure that it's in compliance.
And by the way,
permanently in compliance.
Does our record tell us, someplace like Mass General, one of these large hospitals, do we know what the estimated cost of something like this will be? Is that in the record?
We submitted in the other appeal a brief on behalf of the Mass Hospitals Association, which estimated that I think in addition to filling an existing gap of about 1,200 nurses, there's a shortage of about 1,200 nurses already existing. Another 4,500 nurses would have to be added. And when you consider
So at one hospital, you could have to add 6,000 plus nurses?
No, that's overall, that's statewide.
Overall?
Oh, yeah,
Okay.
that's statewide. I am not aware of any information on a hospital-by-hospital basis, no. Obviously, bigger hospitals would have to add more nurses, but smaller hospitals have more limited finances.
So your position, as far as it relates to the workforce restriction on employees being terminated, that there's an argument that can be made that almost any employee in some theoretical way could have an impact on the quality of care?
There's two things there. I think there are two things buried in that. One is, insofar as the putative purpose is patient safety, I think there are large categories of employees who, except in the most attenuated knee bone connected to the ankle bone sense, would not have that kind of effect, and certainly would not have the kind of effect that Justice Gantz was talking about, where that person does a job, and if that person's job goes away, then a nurse is going to have to do that job. If you're talking about quality care, and that's an interesting point, the healthcare workforce is defined partly in terms of employees who have an effect upon the delivery of quality care to patients.
To patients, quality of care to patients.
And
right.
that is it's an undefined term in the statute, but as we pointed out in our reply brief, there is at least some acceptance in the broader industry, in the medical field, in the hospital field, to define quality care much more broadly than safe patient care. And that safety is one element of quality care, but so is efficiency, effectiveness, timeliness, and even something called people-centeredness. And so if that is the standard, then you would still be potentially bringing in a large universe of hospital employees, even if you ignored these enumerated categories.
Trying to sort out here this distinction about we're sort of being placed in order to interpret the proposed statute as well as determine its relatedness, which I don't recall us having to do in the previous ballot petitions that I've heard when I was on this court. But does it matter that, and I mentioned 231E, which is the regulations, but I also see that 231C, the certification by the hospital, also says, provided, however, that the certification must be that no such assignment shall result in a reduction in the staffing level of the healthcare workforce assigned to the facility's patients. So the language of assigned to the patients is in both the regulations and the certification, but not in 231D.
I'm sorry, when you're talking about the certification, are you looking at 231B or 231C?
231C.
231C, if it's that second paragraph in 231C, I spotted that assigned to the facility's patients qualification as well, but that doesn't speak to the certification. As I read it, it speaks to the fact that nothing shall preclude a facility from assigning fewer patients to a registered nurse than the limits enumerated in the section, so that, in other words, if the mandated ratio is 4-to-1, it's okay if you go to 3-to-1. However, that assignment can't result in a reduction of the staffing level in the healthcare workforce, and they do have that qualification. If you're talking about the certification, that's in 231B, and what it says is that each facility shall submit the plan certifying that it will implement the patient assignment limits without diminishing the staffing levels of its healthcare workforce. So you're back to healthcare workforce writ large. And I agree with you that needing to interpret a statute before you can determine whether it's related is a daunting task, and it's another reason, a separate reason, we think, why this should not be submitted to the voters, because the debate over the political debate over a ballot initiative should be about what that initiative may or may not accomplish, whether mandated staffing ratios are going to be a good thing for patient safety or somehow be counterproductive. The debate shouldn't be over what the statute means in the first place. And if you have this level of confusion within the proposed statute, such that, for example, the Attorney General is now saying that the deciding factor in who's in the healthcare workforce is whether the person has an effect upon the delivery of quality care to patients, and not those enumerated categories. But if you look at the summary, the one-sentence summary of 231D says that the proposed law would require a facility to comply with the limits without reducing its level of nursing, service, maintenance, clerical, professional, and other staff. And it's talking about it purely in categorical terms. So at the very least, I think you've got that level of confusion that should not be put to the voters, and it shouldn't be put to the proponents and the opponents to have a debate about what the statute means before they can have a debate about what the statute will do or not do.
But that can be part of our decision. If there's that inconsistency, we could require clarification of that, couldn't we? If the Attorney General's description is inconsistent with what the bill does,
I think you can require clarification of the summary, but you couldn't require clarification of the statute itself, yes.
I get it.
All right, thank you.
Thank you.
Ms. Rice?
Thank you, Your Honor. Good afternoon. With respect to the questions on interpretation of the statute, in the Abdow case in 2014, the plaintiffs had argued that the measure that was before the court at that point would not have its intended effect of prohibiting parimutuel wagering on simulcast greyhound races. And this court concluded that to discharge her constitutional obligation to prepare a summary of the measure, the Attorney General, quote, must inevitably form her own understanding of the measure of the language in the initiative and its operation and effect. And the court went on to say that where her understanding is reasonable, it would not be disturbed by the court at this certification stage, and went on to state that the proper time for deciding definitively whether the measure has the desired legal effect will come in if and when the measure is passed. In the meantime, the pros and cons of the measure, including its possible legal flaws, are best left to public debate in the electoral process.
yeah, I find that sort of troublesome that we're going to put something in. If something's confusing, we're going to find out whether it passes or not. Maybe it passed because people were confused. I don't know if that's such a great solution if there is confusion.
Well, this court has never, and Article 48 does not provide a basis for holding drafters of initiative petitions to a standard of perfection or a standard that's higher than imposed on the legislature itself.
But we can tell the AG to clarify its statement, can't we?
I disagree, Your Honor. The one time that a summary was called into question before this court, and it's important to note that the Attorney General's summary is not challenged in this litigation, but the one time that it was, in 1951, the court concluded that because the summary was inaccurate, or in that case, incomplete, that the law, and this review was done after enactment of the law, had to be vacated. So there's no provision for eliminating or revising the summary once, in this case, hundreds of thousands of signatures have been gathered on that summary, and there is no claim that it's inaccurate. No claim of that nature ought to succeed in any event. The one provision that my brother is making reference to, counsel for both the petitioners and the opponents here, counsel for the plaintiff, were very involved in drafting that summary, and counsel for the plaintiffs in this case specifically argued against inclusion of the language that was narrowing.
So what is your understanding of the reduction that's precluded? Because it does seem like in your terms, this operational relationship's very important. There is clearly, in the chief's hypothetical, a direct operational relationship. It seems to go beyond that, or do you believe the statute's actually limited the way the chief's hypothetical reads, or do you think it's broader than that?
I think we certainly have to give effect to all of the language in the proposed law, as the chief has pointed out. The language in the definition of healthcare workforce that limits that definition to patients that have an effect on the delivery of quality care to patients, and the language in 231E, the regulatory provision that discusses patients or nurses assigned to those patients.
So what does that mean? Does that mean anyone I have great respect for the legal counsel's offices in hospitals. They impact on the quality of care. Are they covered? Are the people who park your cars in a crowded parking lot downtown, they affect sort of how you feel when you get to the hospital? I'm just trying to, what does it mean? Who's covered in your view? Because doesn't the statute need to be clear enough to know whether it's an anti-layoff provision for the entire hospital versus an anti-layoff provision for people who will be who are working in those wards where you're taking care of people?
Sure. The first point is that even the plaintiffs here don't argue that this provision is a perpetual employment guarantee for everyone in the hospital. They acknowledge, as they must, that the staffing reduction restriction a violation would be triggered only if a staffing reduction resulted from implementation of the patient assignment limits. That's the first and most important narrowing principle. But secondly, what the law does is it provides us guidance.
How does that work in the real world? Just so the costs are going to go up in the hospitals. I mean, I guess they could lower people's salaries, or they can increase the parking revenues. I don't know. There are a lot of options, but
There are. And what this provision does is it takes one of those options off the table. It doesn't take all of the options off the table. It says, as a method of implementation of the patient assignment limits, this is one way you cannot do it. How will we know if either an in-house attorney or a certified nursing assistant has been laid off as a result? If you could make the case that that in-house attorney met the definitional requirements here, the Health Policy Commission has regulatory authority under this law. It would have the first opportunity to gauge and set the limits of its own jurisdiction. And as we frequently do in the employment law context, we sometimes have to determine if it can look like multiple reasons going to a layoff or a reduction in staff. Nothing in this proposed law would prevent any staff reduction except as a result of the implementation of the limits.
Ms. Rice, I'd like to ask you about, I think it's the Stewart Hospital amicus brief.
Yes, Your Honor.
So obviously, your point about the political nature of the issue has nothing to do with our decision, but the Stewart Healthcare brief talks about, really, they don't frame it this way, but they basically say the provisions are not related, and you've got the sort of nursing staff ratios are lower. That's going to be very attractive to a lot of people. But don't worry, we've got you can have your cake and eat it too provision of no restriction on workforce that would anyway be related to the quality of care. And I think they're arguing through that's got a relatedness problem. What's your response to that, if I've captured their point right?
I think if in fact Section 231D proposed, say, a goodie basket that would do nothing more than say nobody can ever be fired for any reason in this facility, and the hospital, must, continue to increase its employee census and can never decrease it. There certainly might have been more of a relatedness problem here. But the court has held on multiple occasions, going back to the MTA case in 1981, that choices about how a particular law is to be implemented, subsidiary provisions that guide the implementation of that law, and those policy choices are up to the drafters, as long as the resulting proposal hangs together and meets the relatedness requirements such that it is fair to ask voters to consider it. Even as recently as 2016, this court held in Hensley that where a proposed integrated scheme implementing a regulatory change is presented to the voters, particular policy choices, in that case it was whether or not and how existing medical marijuana treatment centers would be permitted to enter the commercial market. The argument was made that that provision was unrelated to the overall legalization scheme, and this court rejected that and said that the drafters get to choose. And in this case, the drafters could have chosen, as my brother Mr. Nathanson stated, Section 231C could exist happily without Section 231D. It could, but the court has never held that petitions must be drafted as narrowly as possible, and their policy choices do not remain within the discretion of the drafters. Now, it certainly may be the fact that the drafters, in choosing not to grant more flexibility to hospitals that would be subject to this law if it's enacted, may sow the seeds of the rejection of this question. And certainly in the political debate that will follow, if the question appears on the ballot, the argument will be made very strongly, I'm sure, by the plaintiffs here and the organizations they represent, that in fact this law is too draconian, demands too much, and doesn't leave enough flexibility. And that may guide voters to reject it. That is not what the Attorney General is supposed to be looking at, nor what this court is supposed to be looking at. We are supposed to be looking at whether it presents a unified statement of public policy with subsidiary policy choices that are related to that, to the voters. And certainly this proposed law is a lot less complex and has fewer parts than the proposed law that was before this court in the Hensley case or before this court in 1981.
Why is this, though, why is this so much more related than the one you rejected? That's what, I have trouble, I see the relationship here and sort of a broad relationship, particularly if you take out the category identified by the chief. But there's also a relationship between, this is going to increase costs for hospitals, and the other provision says, tell us about all your assets. But you say that's not related. You seem to have a sort of a broad relationship on the one and a narrower relationship on the other. How are they different operationally?
They're different operationally because there's no connection in the...
But there is a connection. There's a connection in this. This is going to increase costs. One bill says you can't lay off anybody to pay those costs. The other bill says, prove it. You got plenty of money. We want to see it.
But prove it to whom, Your Honor?
Prove it to the employees or the public, because the defense is going to be, as you just stated, this is too draconian. It's going to have other consequences. I get why this is related in some sense, in a broad way, not narrowly tailored, but good enough.
When Your Honor raises the point of, or uses the term defense, there certainly may be defense and argument in the political sense, and maybe even in the collective bargaining sense, but not in a legal sense.
Well, but it's going to be in an operational sense. Hospitals have to operate. This petition will significantly increase their costs.
Yes, Your Honor.
And they're going to have to react to that. One petition takes off the table layoffs. I get it, they're connected somehow.
Both petitions do, Your Honor, just to
Yeah,
clarify.
no,
but
I know,
yes.
that's what I mean. But then the second one says, I can't look at your financial records. And to me, it's because that's too broad. The connection is too attenuated. But the layoff provision isn't so narrowly tailored either. It isn't the provision described by the chief, which makes complete sense. It's a don't lay off basically, don't increase nurses. Don't worry, you won't lay off anyone else. So that's pretty broad.
Well, I agree that it is broader than the example given by the chief. I disagree that it is so broad as to present an entirely different public policy question that would disqualify this petition from being certified under Article 48.
So, but why is the other one too broad then?
Because there are two problems with the other one. One is that it is too broad in that it is not, I don't know if broad is exactly the right word, but it is not focused on generating information about resources to pay staffing costs. And this whole thing is about staffing. The other, which is I think the bigger problem that we're talking about, is that it is not connected in any way. You can say, what's the hospital's defense? The defense is we can't afford it, but there's no provision that would allow them to make that showing, thereby being relieved of the obligations of the law.
What do we do with the summary, which I see now in the record is A098, where there is one provision which speaks about assigned to, two provisions which say assigned to such patients, another provision which does not. The summary, as I read it, said the proposed law would require a covered facility to comply with the patient assignment limits without reducing its level of nursing, service, maintenance, clerical, professional, and other staff. That appears to be a 231D definition, not a 231C or E.
I believe that's a 231A definition, Your Honor, which is the definition of healthcare workforce, which is the term used in 231D.
But it doesn't narrow its scope as 231C and E does to assign to such, they speak to the staffing level of the healthcare workforce assigned to the facility's patients, which is a narrowing of its scope. But I don't see in your summary that there's a narrowing of the scope.
It is true, Your Honor, that we did not carry forward that particular language. There was an awful lot of discussion about it. We necessarily have to be concerned about the length and the complexity of the summary, and we are always trying to balance clarity for the voters with the provision of information. We viewed the patient assignment limits themselves as the most important part of the proposed law, and that's why they lead the summary. The second page, after the bullet points of the summary, and this is in the record at starting at page 071, is that we state the proposed law would require a covered facility to comply with the patient assignment limits without reducing, and that's the result intersection point that I discussed earlier, its level of, and then we give nursing, service, maintenance, clerical, professional, and other staff, and that comes from Section 231A's definition of healthcare workforce. You could argue that we should have included the words that have an effect on the delivery of quality care to patients. We certainly considered that. We viewed that as adding a lot of words that would not necessarily advance voter understanding of this provision. Maybe we could have added, without reducing its level of certain staff. Again, I don't think that would advance voter understanding of this provision. And in this subsidiary implementation provision, we viewed that as not a good use of voters' attention in paying in their review of the summary.
So since we expect voters to be relying upon the summary and not necessarily attempting to dissect the different provisions, it sounds as if the AG has determined that the public should vote on it as if it is essentially a no layoff provision as opposed to no layoffs with regard to those that may affect the staffing levels of those, quote, assigned to such patients.
I think the most important thing here is the connection between the implementation of the limits and the triggering of the workforce restriction reduction, and that is evident in this line in the summary. Your Honor is correct that this
Which line in the summary says it? It's
must comply without reducing. Not that it can never be reduced, not that workforce can never be reduced, or that employment positions are subject to a general perpetual protection, but the patient assignment limits must be implemented without reducing other healthcare workers. And I'll point out again that there is no challenge to the accuracy of the summary before this court.
Right. My question is not that. My question is, when we are interpreting the statute, do we interpret it pursuant to your summary, or do we, which is essentially a broader definition of the layoff provision than is also provided in 231C and 231E?
I think this court remembers that the job of the Attorney General in preparing her summary is to identify and summarize the main purposes of the proposed law in a way that is understandable to most voters. And simply reciting terms of art in the statute that we in a court can argue about does not do a service to the voters.
You say terms of art, but I mean, your brother basically said that term of art, whether or not this is an overall no layoffs for this category, these categories of employees, or no layoff of these employees with regard to those who are assigned to such patients, is a big deal, because everybody keeps talking about the in-house counsel. Well, in-house counsel are not assigned to patients.
I think the
clerical people may, other people, LPNs may be assigned. I mean, so you're saying it's irrelevant, or you're saying, I'm just trying to figure out what you're saying we're supposed to do with that.
I'm saying that it is not a central enough feature that we thought it made sense to take up the voters' attention with this fairly subsidiary point that is going to have to be regulated by the Health Policy Commission, whether an in-house attorney might be considered assigned to a patient or having an effect on the quality of patient care. That could be the case in a particular situation. I don't know. But it is certainly not unusual that laws proposed either by the legislature or by citizen legislators themselves need to be implemented in such a way, and we may not know that this in-house lawyer will never be subject to the protections of 231D. This in-house lawyer may be in a certain situation, and this other one may not be. It does not do a service to the voters for us to be.
But doesn't that suggest then that the AG's concluded that a no layoff provision, the broader version, is sufficiently related that it can be one petition?
Even the broader version, Your Honor, would be because of the result language. It is tied to 231C by the requirement that layoffs may not result from implementation of the limits.
So just so I make sure I understand, so you're saying that because the broader no layoff, no hospital employees can be laid off resulting from the implementation of this staffing level requirement is sufficiently related?
Yes, Your Honor. That would be our position. I thank the court for its time.
Okay, thank you.